The current economic situation has led to many companies in the US either reducing their workforce or planning to do so, causing employees to experience anxiety about the possibility of being laid off. They live in constant fear of discovering that they have lost their job. Employers, too, are faced with the difficult decision of letting go of valuable employees to survive. However, there is an early warning system that can help alleviate some of the stress: the WARN Act, short for Worker Adjustment and Retraining Notification. The WARN Act requires employers to give notice in advance of any plant closing or mass layoff that will result in job losses for a certain number of employees. Failure to comply with the Act can result in legal penalties for the employer. The law describes employment loss as one of the following: 1. When someone is fired for reasons other than misconduct, quits voluntarily, or retires; 2. When someone is laid off for more than 6 months, or 3. When someone's work hours are reduced by more than 50% per month for 6 months. According to the WARN Act, employers that meet certain criteria must provide written notice to their employees at least 60 days in advance of a plant closing or mass layoff. This applies to plant closings that affect 50 or more employees during a 30-day period, or mass layoffs that affect at least 50 to 499 full-time employees, constituting at least one-third of the workforce at a single site of employment within a 30-day period. For layoffs affecting 500 or more employees, the requirement applies regardless of the percentage of the workforce. The WARN Act typically considers the number of employment losses that occur within a rolling 30-day period. There are certain circumstances in which the WARN Act does not require employers to give a 60-day advance notice. These exceptions include situations where an employee is offered a transfer to a different location within a reasonable commuting distance, the closure or layoff is caused by unforeseeable business circumstances or a natural disaster, or the closure or layoff is a result of a strike or lockout that is not intended to avoid the requirements of the WARN Act. Also, there are also state-specific versions of the WARN Act. For example, in California, there is a state version called Cal-WARN, which is similar to the federal WARN Act but with some differences. Cal-WARN applies when a covered employer with 75 or more employees lays off 50 or more employees within a 30-day period. It also applies when a covered employer relocates operations or terminates operations, resulting in a loss of employment for 50 or more employees within a 30-day period. In addition, Cal-WARN requires the same 60-day advance notice as the federal WARN Act. Similar to the federal WARN Act, the Cal-WARN Act also has exceptions where providing a 60-day notice is not required. Some of these exceptions include situations where seasonal employees were hired with the understanding that their employment was temporary, or if a natural disaster or act of war necessitates a mass layoff, relocation, or plant closure. To be considered for notice under the federal WARN Act, employees must have been employed by the employer for at least 6 of the previous 12 months. If an employer fails to provide the required notice under the WARN Act, they may be liable in a civil action. This may include paying back pay, a potential civil penalty of $500 per day for each day of violation, covering medical expenses for employees that would have been covered under an employer-sponsored health benefits plan, and paying reasonable attorney's fees. Google WARN Act and the state name.